in this case, Eega Soumya versus Mahender Reddy. In this case, Supreme Court held that the right victim statement under Section 164 CRPC must not be disclosed to any person, including the accused, till the charge sheet is filed. So, certain cases referred here. So, I go through the certain cases, important cases referred here. First one is the state of Karnataka in non-Minakar police versus Shivanna Tarkari. In this case, Supreme Court suggested certain directions, certain guidelines. And first guideline is when the investigation officer got informed about the commission of offence of rape, the investigating officer shall make immediate steps to take the victim to any Metropolitan Judicial Magistrate for the purpose of recording her statement under Section 164 CRPC, and also the copy of statement under Section 164 CRPC should be handed over to the investigating officer immediately with a specific direction, and it should not be disclosed to any person till the charge sheet or report under Section 173 CRPC is filed. And second one is the investigating officer shall as far as possible take the victim to the nearest Lady Metropolitan or Lady Judicial Magistrate to follow the directions of this court. And third one is the investigating officer shall record specifically the date and the time at which he learned about the commission of offence of rape, and date and time at which he took the victim to the metropolitan, preferably the lady judicial magistrate. And fourth one is if there is any delay exceeding 24 hours in taking the victim to magistrate, the investigating officer should record its reasons for same in its case diary and hand a copy of same to the magistrate. And fifth one is Section 164A CRPC, which provides that the investigating officer to get the victim of rape immediately medically examined and a copy of report of such medical examination. It should be immediately handed over to the magistrate who record the statement of victim under Section 164 CRPC. These are the five guidelines which was provided by court in this case. Then another case referred here is A versus State of UP. It was held in 2020-10 SCC 505. In this case, the Supreme Court held that no person is entitled to a copy of statement recorded under Section 164 of CRPC 1973 till the appropriate orders are passed by the court after the charge sheet is filed. The right to receive a copy of such statement, it will arise only after the cognizance is taken and at the stage contemplated by Section 207 and 208 of the Code, and not before it was observed. Another case is referred here is State of Karnataka versus Shivanna. In this case, no person is entitled to a copy of statement recorded under Section 164 CRPC till the appropriate orders are passed by the court after the charge sheet is filed. The right to receive a copy of such statement, it will arise only after the cognizance is taken and at the stage of contemplated by Section 207 and 208 of CRPC, and not before. Section 207 CRPC, which provides that supply to the accused of copy of police report and other documents. Section 208 of CRPC, which provides that supply of copies of statement and documents to the accused in other cases which is triable by court of session. Here we know that the main purpose of recording statement under Section 164 of CRPC is to deter the witness from changing their versions subsequently and to get over the immunity from the prosecution in regard to information given by the witness under Section 162 of the Code, CRPC. Another reason for recording statement of witness under Section 164 of the Code is to minimize the chance of changing the versions of the witness at the time of trial under the fear of being involved in perjury. Also here, the Section 145 of Evidence Act is also plays a crucial role here. It provides that the cross-examination as to previous statement in writing. The Section 145 of Indian Evidence Act does not speak about as a statement recorded under Section 162 or 164 of the Code. It is to be considered as a previous statement in writing. Thus, the both statement recorded under Section 162 and 164 of the Code are the previous statement to invoke the Section 145 of the Act. So, hence the magistrate has been given the discretion to record the statement of witness either sponsored by investigating agency or the witness directly before the court for recording such statement.
So The present contempt petition here seeks to highlight the conduct on part of the alleged condemners in willfully uh, violating the mandatory directions issued by the court. So the directions which are put in focus are those which were issued in the decision delivered in state of Karnataka by the police versus Shivana alias under the name of Tarkari Shivana, which is a 2014 case. And the court stated that on considering the same, we have accepted the suggestion offered by the learned counsel who appeared before us, and hence exercising powers under Article 142 of the Constitution, we are pleased to issue interim directions in the form of mandamus to all police stations in charge in the entire country to follow the directions of this court, uh, which were then stated by the court. So a few of these guidelines were that upon receipt of information relating to the commission of offense of rape, the investigating officer shall make immediate steps to take the victim to any metropolitan or judicial magistrate for the purpose of recording a statement under Section 164 of the CRPC. A copy of the statement under Section 164 CRPC should be handed over to the investigating officer immediately with the specific direction that the contents of such statement under the section should not be disclosed to any other person till the charge sheet or the report under Section 173 of the CRPC is filed. Nextly, the investigating officer shall, as far as possible, take the victim to the nearest lady metropolitan or lady judicial magistrate to ensure gender preference. And the investigating officer shall record certain documents in an unbiased manner. And nextly, I would like to state that he or she needs to record the date and time at which he or she learned about the commission of the offense of the rape, and the date and time at which he or she took the victim to the metropolitan or lady judicial magistrate, as before said in the guidelines. If there is any delay exceeding 24 hours in taking the victim to the magistrate, the investigating officer should record the reasons for the same in the case diary and hand over a copy of the same to the magistrate. And medical examination of the victim is defined under the section 164A of the CRPC inserted by Act 25 of 2005 in CRPC, and it imposes an obligation on the part of the investigating officer to get the victim of rape immediately medically examined. A copy of the report of such a medical examination should be immediately handed over to the magistrate who records the statement of the victim under section 164. And on a similar issue, the matter was again dealt with by the court in A versus State of Uttar Pradesh and others, which is a 2020 case, in which, after referring to the decision of the court in Shivane case, it was observed uh, in the following guidelines. So, merely because the charge sheet was filed by the time the High Court had passed the order, which is a case that resembles Chinmayanath versus State of UP, which is a 2019 case. In the present matter, did not entitle the second respondent to a copy of the statement under Section 164. And setting that aside, the reason that weighed with the High Court in placing reliance on the decision of Raju Janaki Yadav versus State of UP, which is a 2012 case, uh, of the division bench of the High Court rendered that in the year 2012, which is before the directions were passed by the court, as in the case of Shivana versus state of Karnataka, it was completely incorrect. And as a logical extension of the directions passed by the court, no person is entitled to a copy of the statement recorded under Section 164 till the appropriate orders are passed by the court after the charge sheet is filed. And the right to receive a copy of a said statement will arise after only cognizance is taken and at the stage contemplated by sections 207 and 208 of the CRPC, and not before that. The application of the second respondent shall rightly be rejected by the additional sessions judge, and the order so passed does not call for any interference by the High Court. So that is my analysis. Thank you.
Uh, Almost all the members in this group has correctly and rightly mentioned about all the aspects of the case with regard to giving details of 164 statement with a particular reference to a woman or a offenses against women, etc. So to begin with, I would like to give a basic understanding by starting with the contempt. What is the meaning of contempt? In Suras India Trust versus Union of India, which is 2021 7 SCR 1063, the raison d'etre of contempt jurisdiction. It was mentioned in paragraph in the judgment that the raison d'etre of contempt jurisdiction is to maintain the dignity of institution of judicial forums. So this case is one such premier case wherein the judgment, a three-judge judgment of the Supreme Court of in Miss A versus State of UP and another was not followed or was not adhered to. In the present case, a lady has been a lady has been subjected to some kind of sexual offenses, and she has been her father has approached this forum claiming that the statement she made to the magistrate was given as 164 statement. Oh, that is 164 statement was given to the accused also. So two cases find importance in this scenario. One is obviously state of Karnataka by Nona Vinatari Police versus Shivana alias Tarkari Shivana. And the second case is Miss A versus State of UP and another. In the former case, it was held in paragraph 10 that to spell out to all police stations to not furnish 164 statement until filing of police report under section 173 CRPC with the magistrate. So it was like giving a direction to all the in the judgment. It was mentioned that it is to give directions to all the police stations in the country to not furnish 164 statement until the police files the report with the magistrate as per section 173 CRPC. So here in this present case, the court denies the fact that it has supplied the necessary document to the uh, uh, to the main accused. And in the second case, that is Miss A versus State of UP and another, which is a three judgment. Here also the same issue arises, and the accused asked for the statements of the victim, which is under section 164, and we must appreciate the uh, the additional district and sessions judge at that time who rendered the application infructuous by observing that if the copy of 164 is given at this preliminary stage of investigation, then besides spilling of all the beans of investigation before the concerned person, who shall also come to know names of all key witnesses involved in the case, the health and safety of the victim, and also that of the key witnesses will be impaired. This was the observation made by the additional sessions district and sessions judge. But I wonder, the Allahabad High Court has turned down this judgment and allowed for giving the accused the copy of 164 statement, stating that the decision of the Supreme Court in the former case, as I mentioned, was only applicable to police and not to the court. This was the main contention of the Allahabad High Court at that point of time. But Supreme Court reversed this in this particular case by observing that it is only after taking the cognizance and issue of process that the accused is entitled, in terms of section 207 and 208 of the code, to the copies of the documents, which includes section 164 statement. And so I believe in this present case, the obviously, because if the court admits that it has given the statement when asked, then it will be in trouble, and the concerned officers will have to face the brunt of the law. So they denied giving, saying that the statement was not given by them. Then, in my opinion, a criminal investigation must be conducted. And this Supreme Court has said in this particular judgment that this case need not be taken, or there is no substance in this case to have been considered to have considered this case as a contempt case. And it recommend it also yes, it accepted all the contentions of the accused in this case, and just hoped that in the future again every police stations or all the courts will follow this judgment, that is Miss A versus State of UP. But I believe if a correct and prompt action is initiated by the Supreme Court, if the Supreme Court had a spine, then it should have initiated a criminal contempt against that presiding officer of that particular court, because he is supposed to be acquainted with the facts of this case, that is Miss A versus, which is a Supreme Court decision, and he should have had not given uh, the copy of 164, because the seal or the stamp, as mentioned in the particular facts of the case, clearly mentions that it was given by the court. Then, if the court denies it, then there should be a criminal investigation initiated, and the particular clerk who was behind must be booked as per 409 IPC, which is criminal breach of trust by public servant. Or else, if the investigation reaches another state where the presiding officer himself has initiated this, then the presiding officer should be tried under Section 14, read with Section 16 of the Contempt of Court Act. This is what, if this is what uh, the Supreme Court had would have done, then it would have been a clear message to almost all the courts in this country. And in one fine day, almost every courts in this country would have come to the information, or the dictum which has been laid down by this court in Mrs. A versus State of UP, and there would have been not a single court which will give or tell the details of and which is meant with contention and my opinion in this case.